All right, thanks everyone for being here. My name is Gary Keibel. I'm a partner with a law firm in New York, Davis & Gilbert. We do a tremendous amount in the marketing and advertising industry, and I co-lead our privacy and ad tech practice. Here's my contact information in case you want to sync up with me. And while I normally speak about privacy issues all the time at conferences and data, AI is definitely the hottest topic out there right now, as we've heard over the past hour and a half or so. And so I'm not really here to scare you about AI, so I'm just going to scare you about using AI. Because there are some legal issues to be concerned about. And honestly, I'm here to help you mitigate those issues. You can't eliminate those issues. It's all very new, but it's all about mitigation. But it's, as we say here on this slide, things are changing daily. I mean, in the privacy world, I always said things are changing daily. Maybe in the AI space, things are changing hourly. But it's being used in marketing, and people are starting to engage with it. So let's take a look at one example of the AI being used in marketing.
Hey, it's Ryan Reynolds, owner of Mint Mobile. We're always looking for ways to save you money. So this year, we're kicking things off with an ad that I created using ChatGPT, the AI technology. This is what I asked it to write. I said, write a commercial for Mint Mobile in the voice of Ryan Reynolds. Use a joke, a curse word, and let people know that Mint's holiday promo is still going even after the big wireless companies have ended theirs. This is what it wrote. Hey, it's Ryan Reynolds here. Eerie. First of all, let me just say Mint Mobile is the shit. But here's the thing. All the big wireless companies out there are ending their holiday promos, but not Mint Mobile. We're keeping the party going because we're just that damn good. Give Mint Mobile a try. And hey, as an added bonus, if you sign up now, you'll get to hear my voice every time you call customer service. Just kidding, that's not really a thing. And stay classy, everyone. That is mildly terrifying, but compelling.
Okay, so there are certainly ways to use it in marketing and making a joke out of it. But when we look at AI from a legal perspective, I'm always thinking about three things: the training data, the inputs, and the outputs. And you don't have transparency into everything. So the training data, what data is the AI scraping around the internet to learn and develop the outputs? And we don't have much transparency there, and that's going to create some of the legal problems later on. But inputs, what do you ask the AI to do for you? And that you are in control of. And as we're going to talk about during this presentation, that's where you need to be careful not to ask the AI to do something that could ultimately create a legal problem. And then the outputs. Again, you don't have much control over what that output is going to look like, and we're going to talk about who might be liable if the output causes a problem. So in legal concepts, there are lots of different theories and things going on here. There's copyrights, trademarks, right of publicity, privacy, and contractual issues. So I'll talk a little bit about each one of those. So copyright. So what is a copyright? A copyright is your protection for an original work of authorship. So if you write a book or write a song or paint a picture, that's a creative expression, and you would own that original work. And ownership is the minute it's created. You don't have to necessarily register with a copyright office, although you could, because you can't sue somebody unless you register. But the minute you create it, you would own it. Although the Copyright Office has already said, as you see down in the bottom there, the office will refuse to register a claim if it is determined that a human did not create the work. So this might sound like a new concept to you, that the United States Copyright Office has just decided that copyrights can only be awarded if it's created by a human. But it's actually a concept that's been around for a little while. There was a case back in 2011 about a monkey, and actually I looked it up. It's a crested macaque monkey named Naruto. And there was a very famous photographer, David Slater, and he was out photographing these monkeys. And he left his camera down, and the monkey, by itself, picked up the camera and took a selfie. That became known as the monkey selfie, and it's the coolest picture in the world. I mean, Naruto's smiling and actually took his own picture. And so this picture started spreading all over the internet. Mr. Slater was like, hey, that's my photo. And he started sending takedown notices to everybody to say, that's my photo, I own the copyright, take it down. And the US Copyright Office said, you don't own the photo, Mr. Slater, because you didn't take the picture. The picture was taken by Naruto. So a copyright can only be owned by a human who created the work, and Naruto created that work. When that ruling came out, then PETA got involved and said, wow, a monkey can own a copyright. And they actually sued, but they didn't win. But the important point there is that this was going back over a decade ago, Copyright Office saying very clearly, if a human doesn't create the work, then you can't own a copyright. And before AI, you were able to control what happens with the works you created. There was this very famous artwork by Shepard Fairey, took the very famous picture of President Obama, turned it into a piece of artwork, but he did enough to change it to make it transformative so that he could own this new output. Well, when you're not in control of the output, then you're not in control of whether or not you've moved far enough away from your inspiration that you can own something new. Because a style can't be owned under copyright law. You know, if I painted a beautiful, painting of the Palmetto Dunes golf course, that doesn't mean that nobody else can ever paint a painting of the Palmetto Dunes golf course. Somebody else can do it, but they can't just do it in a style that's close enough to mine that it's almost a copy. So, if you went to Dali and said, I want a painting of a fox sitting in a field at sunrise in the style of Claude Monet, you get something kind of close. So you control those inputs. So you need to be careful not to ask for something. Fortunately, Monet died in like the 1920s, so you probably wouldn't have a claim. But if you ask them to create a piece of artwork in the style of someone who's still around, you might get a claim if it looks that similar. So trademarks. So what is a trademark? And there's one of the most famous trademarks in the world right there. A trademark is a slogan, an identifier that identifies for consumers the source of goods or services. And so you could certainly say to AI, I want a picture of a monkey drinking a bottle of soda or a photograph of a couple eating at a fast food restaurant. And you might get output that's going to have a trademark in there. And so you need to be careful about using that because you might have a claim from the trademark owner that you've got trademark infringement there. And then another one, right of publicity. So right of publicity is the right of every person to control the commercial exploitation of their image. So if you had a picture of a celebrity and you said, hey, this celebrity is using my product, I'm going to put them in my banner ad or on my website, you'd be violating their right of publicity because celebrities obviously get paid a lot of money to be in ads. But with AI, you can create interesting things. There was this case talked about in the New York Times where an image was created with Midjourney, and the prompt to create it was, I want a young man sitting on the couch with headphones on in the style of iconic pop culture references, prairie core, avocado punk. I must be 1,000 years old because I don't know what any of this means. Photo taken with Kodak Porta, Garden State intense gaze, modular movie still, and you get this output. Now, if this output looked similar to a particular celebrity or star, they would certainly bring a right of publicity claim against you, even though you didn't intend to evoke their specific image. Again, the output might end up being very close to one particular celebrity. So who's liable when all this goes wrong? And that's the big open question right now. Because when you use a platform, you obviously accept terms of service to use the platform, and some brilliant lawyer drafted the terms of service. And that's the contract between you and the platform. But between other people outside of that contract that you might infringe their rights, they don't care about your contract. They care that you're just using something that violates their rights. So when we look at contracts, you need to pay very attention, and there's a lot of old contracts that have been around forever. I think about contracts between like an agency and a client. And the agency says, everything we create for the client will be original, and you, client, will own all the creative work we do. Well, that doesn't make sense with AI. It may not be original, and we're not sure who owns it. So I've actually seen clients come up with addenda when they're using AI for a client. It's really, really important to be transparent when you're using AI and tell the other party what you're doing, and then maybe address liability between the two of you because maybe you don't want to be liable for the output that's generated by the AI. SAG and AFTRA has gotten involved here in terms of talent and celebrities because they're worried about deep fakes, and they don't want people to be using deep fakes to avoid hiring the celebrities and then avoid paying the union rates for pension and health when you actually use a real celebrity. So using those deep fakes is a real issue for a lot of folks because it's cheaper than hiring the actual celebrity. So all the use cases, there's tons of use cases out there. You could create copy for advertising. It can help with your SEO. It can do market research. All these different things that can do, which can generate many, many different outputs. So here's an example of one campaign. Coca-Cola had this campaign where they actually released authorized brand design elements and told users, go to Dolly and create something using the brand elements that we've given you. So you've already got permission for using some of the brand elements. But again, what you get in terms of the output, there's not much control. Yes, it has the brand elements in there, but who knows if that picture of the cat being an astronaut is similar to some other's work, or the one with the dog and the robot. You don't know what the output is going to be, even though you're in control of certain inputs. So here's the important do's and don'ts. So a do, be transparent with clients and other partners you work with about AI-generated content. Again, if you had a contract with someone that says, everything I create for you is going to be original, it's not true. Possibly not true if you're using AI. Number two, make sure the AI platform's terms of service allow for the commercial use of your output images. I know you don't want to read the dense legal language, but you might want to take a look at some of them. I don't want to embarrass any particular AI platform, but there was one that a client had sent to me recently that did transcription of video calls between parties and using AI. And when I read the terms and conditions for this platform, it actually said the platform had a perpetual broad license to do anything with any content they collected. So think about using this transcription service to record confidential communications, and the platform has a right to do whatever they want with it. It was probably just poorly drafted. Number three, and this is probably the most important one, use generic prompts for style descriptors. Don't say, give me a vocalist in the style of Taylor Swift, because you're going to get something that's going to infringe. But you want to be a little bit more generic in terms of what you ask the AI to spit out for you. And then assess the likelihood that the AI-generated output may be infringing. Don't just take the output and go off on your merry way. You got to look at it. Think about it. Share it with your team. Say, does this evoke anything that we think we're going to have a problem? This is what we do with other creative works that happen in the marketing space. So don't include references to pre-existing copyright works, trademarks, individual names in the text prompts. Again, don't encourage the AI to make an infringing output. Don't upload pre-existing visual references as a prompt unless you own or have the rights to those. And don't input any confidential or personal information. Now, I deal with privacy a lot, and that's usually a big part of my work. And privacy has become an issue with AI as well. And there's a lot of laws out there, and they're trying to catch up with how they apply to AI. You've probably all heard about the CCPA, the California Consumer Privacy Act. I think according to my marketing department, I was supposed to add text to this part of the slides, so I'll make sure I'll do that when I get back to the office. But CCPA can apply if there's personal data being processed in the AI. Canada has an AI bill that they've proposed. In the EU and the UK, they have been proposing treating AI as what's called a high-risk activity, which requires a certain level of analysis before using it. And in Italy, they've outright banned the use of ChatGPT because it's processing large amounts of personal information. And under the GDPR in the European Union, you need to have a legal basis to process that data. It could be consent, it could be another basis, but the Italy regulators said that ChatGPT has no legal basis for processing all of this personal information in their system. And of course, that can create a challenge if you're in a jurisdiction where suddenly using AI is illegal. So, ChatGPT's terms and conditions. Got to talk about them because they're so important. Here's the most important thing, and I'm going to go through all of this, so I'll read it to you. And ChatGPT's terms, I think, are actually fairly reasonable. You may provide input to the services and receive output generated and returned by the services based on the input. As between the parties and to the extent permitted by applicable law, you own all input. So they're saying, just between us, I don't know about anyone else, and if law allows it, those inputs you type in are yours. We're not going to mess with your inputs. OpenAI hereby assigns to you all its rights, title, and interest in and to the output. And the kind of lawyer weasel word there is its. They're basically saying, if we have any rights in the output, we give it to you. But we're not saying we have any rights in this output because who knows. This means you can use content for any purpose, including commercial purposes such as sale or publication. You are responsible for content, including for ensuring that it does not violate any applicable law or these terms. Due to the nature of machine learning, output may not be unique across users, and the services may generate the same or similar output for OpenAI or a third party. So between you and OpenAI, OpenAI is basically saying, you're on your own. Good luck. You can take, between us, you can take the output, do whatever you want with it. But if a problem ends up with this output, you're on your own. We're not going to back you up. So what are the US regulators doing about AI? Well, the Federal Trade Commission, which regulates everything in the media and advertising industry, and I'll go to the third column there first, the only thing they can really regulate is things that are deceptive and unfair. Like they use this in privacy. If you have a privacy policy that says you don't sell personal information, but you actually do, that's deception. If you had a car commercial that said the car goes 0 to 60 in 5 seconds, but that's not true, that's also deception. It's a really broad right to regulate deception or unfairness. So they've been putting out blog posts to say to people that you could be violating the law in the way you use AI. And the first one there, they say the term AI can be used as a deceptive selling point for products. Don't fool people and say, hey, this cool product's created with AI if it really wasn't. And then the flip side, they say chatbots, deepfakes, and voice clones, AI deceptions for sale, a growing percentage of content is not authentic or synthetic media. Don't try to pass off things as real if they were created with AI. And if you do those things, again, Federal Trade Commission has not brought any actions against anybody, but they would bring a claim that what you're doing is deceptive or unfair. So are lawsuits happening? Yes. In my last 3 minutes here, Getty Images, which controls most of the great images online, they've sued a lot of AI platforms, and they're bringing a host of claims. They're claiming copyright infringement because your training data is going around the internet scraping all of our photos. Trademark infringement because there may be logos inside of those photos, and violation of an artist's right of publicity because you may be using the names and images of artists in those photos. So I think these lawsuits are going to pick up. This one, not really AI, but kind of shows you how new technology hits up against existing intellectual property law. In the NFT world, Hermes won a big lawsuit because someone had made an NFT out of one of their bags. And NFTs were all new and everyone's just running around and creating them. Hermes says you can't do it with our trademarks to make a new NFT. It's the same type of thing with AI. So last thing I'll talk about, I wanted to leave you just in this last slide with some good tips about what to do going forward. And I was sitting in my office thinking about how can I give you guys some good tips to close out the presentation, and I got a great idea. Let's ask ChatGPT. So I typed in, I said, if you were Gary Keibel, what would you tell attendees at a Media Post Summit about using generative AI in marketing? And work in a reference to golf, since I'm a golfer and we're going to be playing golf this afternoon. And here's what it said. As Gary Keibel, I would say that using generative AI in marketing is like playing around a golf. You need to start with a solid foundation, carefully choose your approach, and be prepared to adapt your strategy based on the results you achieve. In golf, you need to have a strong understanding of the fundamentals such as grip, stance, and swing mechanics. That's true. Similarly, in using generative AI in marketing, you need to have a clear understanding of the data and inputs that are being fed into the algorithm, as well as the audience that you are targeting. That's very good advice. Just as golfers carefully select their club based on the distance and obstacles they face on the course, marketers need to carefully choose their approach when using generative AI in marketing. This means selecting the right algorithm and training data, and being prepared to adjust your strategy based on the results you achieve. Finally, in golf, you need to be able to adapt your strategy based on changing conditions on the course, such as wind, rain, or other hazards. Similarly, when using generative AI in marketing, you need to be prepared to adjust your strategy based on changes in consumer behavior, market conditions, or other external factors. By following these principles, marketers can use generative AI in a way that enhances the effectiveness of their campaigns and drives business results, just as a golfer can use the right strategy to navigate the course and come out on top. Well, I think this tells you something very important. You didn't need to invite me here to this conference because ChatGPT can just do it all for me. But it's really very good advice and makes sense. But with that, I'll turn it back over to Morgan and any questions you may have.